The number one mistake founders make on day one isn't a bad product or service, it's a bad legal foundation. And one of the most common pitfalls, either an undocumented equity split among the founders or a lack of vesting for those key personnel. It's the silent killer of co founder relationships and a massive red flag for investors. And I see it every week, a handshake deal that turns into a costly business divorce. My name is Maritza Shea Nelson, and I'm a small business and nonprofit attorney. I help founders, dreamers, visionaries, and innovators pursue their passion without worrying that all this legal stuff might come back to bite them. When launching a startup, the excitement of collaboration can sometimes overshadow the necessary legal infrastructure. One of the most critical yet often misunderstood legal must dos is properly documenting the founder's equity, so who has what percentage in the company, and making sure that if any key service providers or key personnel get equity, there's a proper vesting schedule in place. Vesting is not meant to be a punishment. It's the essential mechanism that safeguards the company's future by ensuring that equity is earned over time and not just granted up front. So, what is vesting? At its heart, vesting is a protective layer for the company. It dictates the schedule by which a co founder or key personnel's shares transition from being subject to the company's repurchase right to being fully owned or vested by that key person. It acts as a sort of golden handcuffs, aligning the financial incentives of those key personnel with the long term success and stability of the business. So if a key person leaves early, they can't just walk away with a huge unearned equity stake that might later be used against the company or dilute future investors. The industry standard that every founder should know about is the 4-year vest with a 1-year cliff. So this is how the schedule breaks down. For the first full year of service, this key person technically owns none of the equity. If they depart for any reason before that 1-year anniversary, they keep zero shares or a 0% interest in the LLC. On the 1-year anniversary of the vesting start date, so typically the date that the shares or the membership interests were issued, then that key person vests 25% of their total equity. So this is the moment that they really earn their initial stake. After the cliff is met, the remaining 75% of the equity vests incrementally on a monthly basis over the next 3 years or 36 months. This smooth, continuous process ensures that a key person is compensated for every month of continued commitment to the startup. For sophisticated investors such as venture capital firms, the presence of a strong founder vesting schedule or key person vesting schedule is a basic due diligence pass fail test. A company where equity is not subject to standard vesting is viewed as fundamentally unstable and a massive liability. Imagine a scenario where a key person leaves after only 6 months, a critical time in a startup's life, and keeps a huge percentage of the company. Investors see this as an immediate, unmitigated risk, especially when it's one of the founders or some other very key person. They are, in essence, being asked to fund that person's premature exit, potentially leading to a dead equity stakeholder who adds no value, but is taking up some portion of the cap table, often a significant portion. Subjecting this type of stock or equity to a standard vesting schedule is not optional, it's standard practice. It signals to the investment community that you, as the founders, are serious, you're sophisticated, and you've taken the necessary steps to protect the company's valuation and long term viability. Beyond the vesting schedule itself, there are two other documents and concepts that are critical to understand to protect the company's future. So, vesting is often enforced through a company repurchase right. So, this must be explicitly documented in your stock or membership interest purchase agreement. This right gives the company the ability to buy back any unvested shares or units in the LLC from a departing key person at the original cost, so typically set at a very, very low value. This single document is the ultimate tool that protects the future valuation of your company by ensuring that dead equity can be recovered. Without this right, unvested shares remain with that key person, cluttering up your cap table and ultimately dramatically reducing the appeal to future investors. As companies mature and they start thinking about long term mergers and acquisitions as a potential exit strategy, these agreements must address what happens to unvested shares during an exit. And this is particularly important, not just for key personnel, but also for founders. And this is where double trigger acceleration comes into play. It's an advanced protective measure that ensures that founders aren't penalized if the company is later sold, often to a bigger company, as a part of the founder's exit strategy. So you'll see two types of triggers. Single trigger. This is where the equity accelerates upon the sale or change of control, so any sort of acquisition of the company. This is often frowned upon by buyers as it removes an incentive for the founders to stay on post acquisition, whether that's to help with the transition or provide some other key services. Preferably, you'll see what we call double trigger, and this means that the equity only accelerates if two events occur. So, one, there's a change of control, this acquisition, often by a larger company, and the founder is subsequently terminated without cause or resigns for some good reason within a defined period of time, oftentimes like 12 months following the acquisition. This structure protects founders by ensuring that an acquiring company can't just terminate them immediately after the sale to avoid paying out on their equity. But it's a critical provision that also aligns the founder's risk with that merger and acquisition process. So stop relying on trust and handshake deals. The ultimate act of self care for your business is putting the right legal foundation in place from day one. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If you love what you do and want to build something amazing, or take amazing to the next level, then let's talk. Check out the link in the description to schedule a consultation.